We now come to the second part of our lecture on strikes and lockouts, and it also includes discussion on foreign involvement in trade union activities and also on the special provisions of the labor relations. Lockout is one of the economic shields of employer against the employees. If the employees have a strike as a way or they resort to make known their demands against the employer have lockout as a response to a labor dispute. It takes place when an employer temporarily refuses to furnish work as a result of a labor dispute, and it involves shutdowns of the business establishment, mass retrenchment, and dismissal. The refusal to furnish work by the employer is a weapon in an effort to get from employees more desirable terms. So in case the employees in a collective bargaining agreement are demanding more than what is required and demanding unreasonably from the employer, then the employer has the means of lockout as a response to it. In a lockout, the plant continues to operate. However, the employee union members are not allowed to report for work, and they are substituted by non-union members to work. In a shutdown, the employer willfully ceases operation following a complete lockout. So in a lockout, hindi magpapapasok yung employer. Hindi niya papasukin yung mga empleyado. And so it means na mawalan ng trabaho yung mga empleyado during the time of lockout. And also, in a shutdown, totally na mawalan ng business operation yung business establishment, which is the subject of a shutdown. And in such case ay walang operation, walang business operation, and so walang trabaho din yung mga empleyado. A lockout, as we have earlier emphasized, is the employer's counterpart of the employee's strike. It's a suspension of operations resorted to by the employer to defeat or sidetrack the demands of the employees to gain advantage over them in relation to a labor dispute. It is a weapon of the employers as distinguished from a strike, which is the command of the labor force. Like a strike, lockouts can be declared based on collective bargaining deadlock and also in unfair labor practice. Because remember, in unfair labor practice, they could be committed either by the employer or also by the labor organization. And also during a deadlock in the negotiations for collective bargaining, as like strike, lockout can be declared by the employer. The following are requirements for the declaration of a valid lockout. First would be the notice of lockout, the lockout vote, and lockout vote report, just like we have in strike. So in case of notice of lockout still has to be filed with the NCMD, and the lockout vote is to be by the vote of the majority of the board of directors. And the lockout vote report is still to be submitted by the NCMD, and it has to comply again with the calling off period of 15 days and 30 days, depending on the basis of the lockout. In case a labor dispute involves an industry indispensable to the national interest, the Secretary of Labor and Employment may exercise his power to assume jurisdiction over it and to certify the same for compulsory arbitration. Indispensable industries or services includes hospital sector. We know the importance of the hospital sector. Also with the electric power industry, no, and water supplies, because these are basic services which should not be unhampered. Even air traffic control, yung nagmamando ng sa pagland ng mga airplane, and such other industries as may be recommended, no, that it has to be. So essentially, kung titignan nyo, these are basic services. Another one important industry could be telecommunications, no? It is similar to this. So in case of labor disputes arising from businesses that are involved, for example, in telecommunications, hospital sector, electric power industry, then the Secretary of Labor and Employment could readily assume jurisdiction and certify it for compulsory arbitration para to avoid the escalation of the situation that would either lead to strike or either lead to lockout. In case there is an assumption of jurisdiction by the Secretary of Labor and Employment, then what happens is there is readily a status quo, the issuance for status quo order, and that involves a return to work order. Ibig sabihin, the situation prior to the declaration of lockout or prior to the declaration of strike has to be kept, no? Kaya employees are required to return to work, while the employer would be required to furnish work to employees. Picketing is a device used by the union to bolster their strike. Ito yung meron yung mga hawak-hawak na placard, no? It refers to outside patrolling or marching to and fro of the strikers at the company's premises. May hawak-hawak sila ng placard which display yung kanilang grievances and other signs that make known the facts involved sa labor dispute. It could involve yung wearing yung mga armbands, yung nagsusuot ng mga t-shirt, yung iba they wear black shirt or they declare yung mga Black Friday, yung mga ganon, which is a form of picketing. And this is a form of freedom of expression, which is constitutionally protected. In order to be lawful, picketing must be carried on peacefully and in conformity with lawful objectives. And picketing is equated with freedom of speech. Etong picketing, hindi naman siya actually strike, but yung ibang strike, they also involve picketing. But it does not necessarily na pag merong picket, meron ding strike. Pero kadalasan, pag merong strike ay meron din siyang kasamang ticket. Ito yung may hawak-hawak na usually ng mga placard, and they express whatever grievance that they have or whatever demands that they have. Limitations on picketing: the commission of act of violence or coercion or intimidation, as well as the obstruction of free ingress or egress. Yung lalagyan ng harang yung malang labasan at pasukan, and obstruct public thoroughfares, yung lalagyan ng harang yung mga roads. Boycott is another form by which employees or even consumers would resort to put economic pressure against the employer. And the purpose of which is to coerce the employer by the restriction and withholding of patronage. Pag sinabing boycott ay wag bibilhin, no? Wag bibilhin ng produkto ng employer. Just like what happened nung nagkaroon ng strike yung sa Nestle Philippines, there was also a call to boycott the products of Nestle Philippines. And that is a call on the customers not to buy products of a certain business. Strike breaker, you take note of the definition of this, is any person who obstructs, impedes, or interferes with by force. Ito yung mga during a valid strike, sila yung manggugulo ng strike, no? During any labor controversy affecting wages, hours, or condition. In the exercise ng right to strike, sila yung mga manggugulo, strike breaker. We have discussed this in the part 1 of the discussion on strikes and lockouts pertaining to the difference on the liability between union officers and union members. No, a worker or union member participating in illegal strike may not be terminated, but when they participate knowingly in illegal acts during a strike, then they could be declared terminated from their employment. It could be a basis for the termination of their employment. As to union officer, their mere participation, knowingly participation in an illegal strike could readily be a ground for their dismissal from employment. As a government employees, they cannot call or join a strike, mass leave, walkouts, and other forms of mass action. We have discussed previously that government employees are primarily governed by the civil service rules and laws. And so the provisions of the labor code is not applicable to them, not unless in certain cases where the government offices are created under the Corporation Code of the Philippines. The terms and conditions of government employees are fixed by law, and so they cannot engage in concerted activities to bring higher salaries or benefits. And the object of prohibition is to maintain the independence and neutrality of civil servants. On Title 8, Chapter 3, on foreign activities, you take note of trade union activities. These are organization, formation, and administration of labor unions, negotiation, and administration, all forms of concerted union action. These all refer to trade union activities: organizing, managing, assisting unions, any form of participation or involvement in representation proceedings, representation election, consent elections, and other analogous activities. These are all trade union activities. Aliens are prohibited from engaging in trade union activities. However, Philippine labor unions may maintain normal contacts. They could have affiliation, or they could have mutual relations with other recognized international labor centers. Legitimate labor organizations are also required to make disclosure of donations against them, because they could be unduly influenced by external forces, and which could undermine yung economy natin. Failure to make such disclosure shall be a ground for cancellation of the union registration certificate. And we now come to Title 9, which is an special provisions, the last topic for labor relations. You take note of the visitorial power of the Secretary of Labor, which could be exercised through the regional or bureau director to inquire into the financial activities of any legitimate labor organization and to examine their book of accounts. And also to prosecute any violation of the law and union's constitution and bylaws. This comes within the supervisory power of the DOLE on labor organizations. And the limitation as to this power is the Secretary of Labor, or through its representative, cannot exercise the visitorial power within the 60-day freedom period. Remember, within the 60-day freedom period is when certification election could be conducted to determine the representative agent for the employees. And also 30-day period immediately preceding the date of election of union officials. You take note of the principle of tripartism in labor relations. It is a declared state policy, and the state is mandated to encourage the representation of workers and employers in policy-making bodies of the government. The tripartite approach is designed to converge yung three sectors, the government, the employers, and employees, for a dialogue and conference for the purpose of drafting major policies and simplifying resolutions of major labor issues. And so it's because yung labor is imbued with public interest, kaya the government makes it a policy that as much as possible, the employers and the employees come into dialogue with the government to determine policies that would benefit both the regulator, the government regulators, and as well as the employers and the employees. And that is to avoid the further escalation of labor disputes, and to promote harmony in labor relations, and to promote harmony in an employer-employee relationship. So that now ends our discussions in labor relations. Thank you.